my name is Akiva Goldman. I'm the director and founder of Goldman and Associates. Our firm has a primary focus on family law issues here in Michigan. And today we're continuing our video series designed to educate and inform the public, so please subscribe to our channel. Oftentimes we're asked about modifying custody. Let me set that up for you. You got a situation where, let's say there's a judgment of divorce. Wife has custody. She's been given the custody under the order or under the judgment, and she's got the custody. The parties have legal custody, and there is parenting time. Dad decides he wants to change the physical custody. He wants custody. Your lawyer will tell you what the law is, and the law is that you can't just go in and ask for custody because you've decided you now want it. The court has to find that there's a significant change in circumstances to even revisit the issue of custody. So the question becomes, what is the change of circumstances needed in order to get the court to say, you know what? I'm listening to what you're saying. I'm thinking we've got to look at this again. It doesn't mean the court will grant it. But what do you need to show the court to even get it to look at the custody issue? What is the change in circumstances that you have to show in order for the court to revisit the issue? I will tell you this. The fact that the child is getting older and now wants to be with dad, that's not going to cut it. The custody arrangement presupposes that the children will age. That's not going to cut it. Things that were easily known or anticipated at the time of the original judgment are probably not going to constitute a change in circumstances. Let me now tell you what will constitute a change in circumstances more likely than not. Number one, a significant change in the life habits of the custodial parent in a downward way. In other words, mom becomes addicted to heroin. That's going to be a change in circumstances. Dad becomes a drug addict. That's going to be a change in circumstances. Or things that have to do with the children. For example, it's December, and in the first quarter from September to December, Tommy has missed 42 days of school. That's going to be something the court's going to take very seriously. Truancy, the court's going to take very seriously. So it's not about, I haven't had my kids for a while and I think it's time for them to come to me. That is not going to work. It's not about, my son is getting older now and he more identifies, he wants to come to me. That's not going to cut it. The preference of a child is a factor above a certain age, but it's one of 12 factors. There's 11 other factors that you got to satisfy. So it's just the fact that the kid wants to go there is not going to cut it. The kid is complaining because one parent is stricter with rules and the other parent is running Disneyland. It's not going to cut it either. It's not going to be enough. The court is going to want to see something significant that goes to the very safety and the health and the well-being of the child. Then the court will look at it. So, in my example, if the kid's missing out, if the kid's going to be held back in school because mom doesn't give a damn and doesn't bother to take the kids to school, or every time the kid says, I'm tired, I want to go, mom's sleeping in bed all day, doesn't care. If that's the kind of household that's going on, mom probably shouldn't have custody in the first place, but the court will correct that mistake. On the other hand, if dad wants custody because mom has a very demanding work schedule, but it's the same work schedule that existed before when the court gave custody to mom, dad's not going to be able to point to that as a change in circumstances. It's just not going to work. So when you talk about what you need to get the court to even reconsider the issue, you're going to have to find something that really goes to the health and the safety of the child, some big change in circumstances that was not contemplated before, that did not exist before, but that now that it's coming up, it could very well impact the child. That's the kind of change in circumstances that will get the court's attention. That's the kind of change in circumstances the court will say, you know what, I know I gave an order giving custody to dad. I'm thinking we got to take another look at that. If you have any questions about whether or not your case has a change in circumstances that's sufficient, reach out and of course we'll be glad to help you out.